Hello, and welcome to this virtual edition of our Capitol Hill Lecture Series. I'm Roger Ream, President of the Fund for American Studies. The Fund for American Studies is an educational organization that sponsors programs around the country for high school and college students, as well as young professionals. We also have programs in Europe, Asia, and South America. If you'd like to learn more about our programs, go to our website at dcinternships.org. Well, it's a pleasure today to be hosting this program virtually for Capitol Hill interns and young people everywhere who are interested in learning more about the ideas of liberty. This program is sponsored in partnership with Senator Rand Paul. Senator Paul was elected to the U.S. Senate from Kentucky in 2010. Prior to joining the Senate, he had a successful practice as an MD and ophthalmologist. Senator Paul and his wife, Kelly, wrote a best-selling book last year, The Case Against Socialism. Today, Senator Paul will be interviewing attorney Sidney Powell, author of License to Lie and the attorney for General Michael Flynn. This is sure to be fascinating, so without further ado, I now introduce Senator Rand Paul.
Well, welcome everybody. I'm Rand Paul, and I'm with Sidney Powell, who's an appellate attorney, famous for a lot of things. But I first heard about Sidney Powell when she wrote a book called License to Lie. And we'll let her tell a little bit about that. But now I would say she's most famous for representing General Flynn. We're broadcasting today to interns across Capitol Hill, but then also online. And then we have some interns here in person trying to obey all the myriad government rules we have to try to put this on. But with that, I'd like to introduce Sidney Powell and let her tell us a little bit about how you got the General Flynn case.
Thank you, Rand, very much, and thank you for having me. Thank you all for being here, and those of you who are watching or listening, we appreciate that too. I guess I got the General Flynn case because I wrote License to Lie, Exposing Corruption in the Department of Justice. I self-published it in 2014 because I had seen prosecutors go from being champions of justice to champions of convictions at any cost. And I was very concerned about what I saw, particularly the conduct of the Enron task force prosecutors, which started before when some of y'all were in diapers probably, but it lasted for multiple years and led to massive litigation that was extremely detrimental to the rule of law and a lot of individual people. For example, they destroyed Arthur Anderson and 85,000 jobs for absolutely nothing. The Supreme Court reversed it unanimously 2.5 years later. And they had done that by making up a crime. They pieced together parts of different statutes to make a crime out of something that wasn't. And then they turned their sights on 4 Merrill Lynch executives for a deal that Merrill Lynch had done with Enron, a year-end deal. And they prosecuted them and sent them to prison for a year on an indictment that had turned out criminalized innocent business conduct. And 4 men spent up to a year in prison on that false indictment. And the prosecutors had hidden evidence that showed they were innocent for as long as 6 years. I stumbled onto the evidence by accident almost, because the third team of prosecutors assigned to the case gave us a disc of material that had been provided to them pre-trial, and it showed that they had highlighted the evidence they knew contradicted their case.
What's the general name for that?
Brady evidence, exculpatory evidence required to be produced to the defendant pursuant to Brady versus Maryland, the Supreme Court decision, because the prosecutor holds all the cards. So they knew exactly what the defense needed to make its defense, and they surgically excised that material from the meager summaries they provided. The Fifth Circuit found that they had provided false and misleading summaries, but they held it wasn't material, so the convictions were not reversed on that basis. But the damage was done to the defendants. The court ultimately reversed 12 out of 14 counts against the Merrill executives. And one young man was acquitted completely after spending 8 months in a maximum security federal transfer facility with the worst of the worst.
And as I read the book, one of the things that was interesting to me was that you've seen both sides. You were a prosecutor, you worked for the Department of Justice, and in the beginning of the book you quote an admonition, I think from an early Supreme Court case, about your job's not just to win, because we're in this world where winning, losing, we gotta win at all costs.
Right.
But what's the admonition to prosecutors about winning?
The admonition to prosecutors is that their job is to seek justice, not convictions. I was an assistant United States attorney for up to 10 years. I headed an appellate section for Western Texas and also for Northern Texas. I think I've done 500 federal appeals, 350 of them in criminal cases, and I tried some criminal cases and civil cases for the government. We were always taught that our job was to seek justice. And if that meant doing a better job in court for the defendant than his own lawyer was doing sometimes, that's what we did. And to tell judges when they could not do something, because there are some judges that are frankly so pro-government in every way that they will go beyond the bounds and do things they shouldn't do that's adverse to a defendant. And our job was to watch out for that too. So there were any number of times I had to stand there as a prosecutor and say, no, judge, you can't do that, which kind of shocks them, but it's good for them.
So it's an interesting sort of setup, as the prosecution is going to try someone, as the government has all this power, as they gather information, it's actually against the law not to give it to the defense attorney. And that's what the Brady material is. They've got to give it up. And in the case, you said it was actually highlighted, and they had just thousands of pages that they didn't turn over to. The other thing you talked about in the book was you weren't part of the Ted Stevens case, but you talked about how some of the same people involved in your case were part of the Ted Stevens case, and the intriguing thing now is some of them became part of Mueller's team in the investigation of Trump. So you had already written about abuses in Ted Stevens, Enron, and then one gentleman, Andrew Weissman, turns up, now he's head of the Mueller investigation. Tell us a little bit about what you know about him and the
Yes.
history.
I called Andrew Weissman the lead villain of License to Lie because he was head of the Enron task force that was most responsible for some of the most egregious violations of law and ethics and everything else as they proceeded to micromanage and prosecute anybody they could find in Texas related to Enron, whether they committed a crime or not. In fact, they wound up making very lucrative sweetheart deals with the few people that actually stole money from Enron, and then pressured those people with all kinds of threats and manipulations to go against other people who had not even committed crimes. So it was a gross abuse of justice, and I can't explain, I have no idea why that happened the way it did, but it did. And then when I saw Weissman named to Mueller's task force on the president and the Russia hoax, I knew that was big trouble, and I knew exactly what tactics they were going to use. So people have called License to Lie Mueller's playbook, essentially, because you could read that and then know what these guys were up to. As soon as I heard that Manafort's home had been opened in the middle of the night and his wife had been searched in bed at gunpoint, I knew that that was one of Weissman's cases. They use what I call prosecutorial terrorist tactics that I find completely unacceptable.
And you actually felt like things that he did in the Ted Stevens investigation and in the Enron were actually illegal. I guess some of that was withholding Brady material.
Yes, and Weissman was not part of the Ted Stevens prosecution, but Matthew Friedrich was, who had worked under Weissman on the task force and had prosecuted the Merrill Lynch executives and Arthur Anderson.
Right.
So there was a lot of overlap.
When I was reading about it in the Enron case, and this I think happens more often in other kinds of cases as well. So there were top guys at Enron who were thieves, right? And some of them ended up testifying against other people, but the one person you defended with Merrill Lynch, I think they said some kind of business deal was self-dealing, but you actually had an email from him saying he was against the deal.
Yeah.
He was actually against the deal that someone said was self-dealing, which was complicated, whether it was or wasn't. But here's a guy who has a paper trail saying he was opposed to it, and they still prosecute him.
Yeah, and actually it wasn't a self-dealing issue. It was at most an accounting issue as to whether the profits should have been accounted for one quarter or the next quarter. And Enron made money on the deal, and Merrill Lynch only made $775,000. The defendants didn't make anything. They were just doing their job, which the judge said as he sent them off to prison. I realize you're just doing your jobs that day. And None of the mayoral defendants even had the authority to approve the transaction. It was all approved above their heads with corporate counsel.
I guess it's one of the things that bothers me sometimes about prosecutions is there was a woman in Dallas I remember reading about a few years ago, and she was an African-American woman, gets caught up in a drug crime. She gets like 25 years of life in prison, but she was a conduit of money between two boyfriends, and they were kind of thugs and probably involved in violence and the drug trade. They both testified against her, got reduced sentences, and she gets this life in prison. And there's no evidence she physically ever hurt somebody. She broke the law and probably deserved something, but I think they got her on a conspiracy charge. And it seems like sometimes they get the wrong person. They go after somebody that the people who really committed a much more heinous crime get off by testifying.
Oh yeah, the real criminal in Enron was Andrew Fastow, the CFO, who stole millions of dollars. And the board at Enron, I think, should have accepted a lot more responsibility than they did, because they approved his dueling roles despite a clear conflict of interest. And he used this separate purpose entity to just scam millions of dollars from Enron and others. But he got the 5-year sentence, and they were trying to send everybody else away for life.
So let's go forward to General Flynn. He's the one, and I don't know all the details, and sometimes we make pronouncements as people in public office, but I've said over and over again, if he was convicted, he's one that should be pardoned, because I think the government either tried to entrap him or abused their authority. Can you tell just a little bit of sort of the story from a top-level view of sort of what went on, what was wrong about the prosecution in general, if you're allowed to the degree you're allowed to talk to us about it?
All the briefs are available on my website at sidneypowell.com if any of you want to dig into it. And they're very readable, even if you're not lawyers or law students or interested that much in the law and just want to know the facts of the case, because I attach exhibits to everything, so you can see the actual documents, the emails, the text messages, different memos. But essentially, the short version of the Flynn case is the government made it all up. They made up a basis to surveil him to begin with. I think we're going to learn that the surveillance went back as far as 2014, when he left the DIA, the Defense Intelligence Agency that he headed for President Obama. He had been outspoken against the problems with ISIS, with Benghazi, with the Iran nuclear deal. Even though he was Obama's DIA, he was trying to warn him about the truth as to everything, as the general knew it to be from his experience and intelligence information. And that was not the narrative that the president then wanted. So Flynn left the DIA, and then by early in the campaign, he was talking to any of the candidates that called him to ask for advice from his perspective to find out what was going on. It wound up that he gelled most closely with President Trump's practical view of things and was an advisor to the Trump campaign. Surveillance really picked up then, as best we can tell, and by the time he was actually named National Security Advisor, the FBI, as we know, had opened Crossfire Hurricane on July 31st of 2016. And then August 5th, and they went ahead and opened cases on Manafort, Papadopoulos, and Carter Page, only because they had Russian contacts. And Flynn, of course, had Russian contacts, as he does with virtually every country from being head of DIA. They opened on Page, Manafort, and Papadopoulos immediately when they opened Crossfire Hurricane. Then on August 15, there's a text message from Strzok and Page to each other talking about the insurance policy they discussed in McCabe's office. August 16, they opened the case on Flynn. August 17, they send an FBI agent into what was supposed to have been a presidential briefing, and they send him in there for the express purpose of spying on General Flynn, collecting any information they can on Flynn, gauging his mannerisms in case they need to interview him as a subject later, i.e. in case Trump is elected to the White House and Flynn is in the White House with President Trump. Then fast forward to the election, and they go on January 24th, 2 days after the inauguration, into the White House in what Ambassador Kislyak. He made those calls as part of the transition team. And he was doing his job, again, as he did that. Everybody knew that. There was absolutely nothing wrong with those phone calls. Even Comey admitted they were completely legit, according to
And didn't
notes
they,
we
the
found.
guys who did the original interview with him immediately sort of conclude that he was genuine, he was not trying to dissemble,
Right.
he wasn't appearing to hide anything? But then
Yes.
when does it change? They immediately thought it was, they sort of said he hadn't said anything untoward, and then when does it change that they changed their opinion? Months later, or?
They never said he said anything wrong to the ambassador. What they came back later, after Mueller came into the picture and said, was that Flynn had not been forthcoming and honest with the FBI agents when they interviewed him.
But how can they say that if you say, well, to the best of my recollection, and it's like, I guess it's why you would think the lesson to everybody in America would be never interview the police unless they say, like if someone says, what about your conversation? Maybe you should say, well, I need to see let me refresh my memory of my conversation so I can ask you questions, because, you know, from a month ago, who could remember everything? If you don't tell everything, does that mean you're not forthcoming, or you forgot one detail that you mentioned in a conversation?
Right, or you misremember something.
Yeah.
In fact, we had an incident in the office yesterday when I was sitting there going, okay, I know somebody said this at the oral argument. And we went through the transcript twice. I mean, I was almost 100% certain of it. Molly and another associate went through the transcript at least 2 times. We could not find it in there. And so even FBI agents who are doing their dead level best, who have the highest integrity, who are trying to get it right, they cannot remember everything that was said in their interview of somebody. And when they go back and they write their 302, it is never going to accurately reflect the interview. So the simple solution of that is to make FBI agents fully record their interviews. But one of the things we learned in the Flynn case was not only did they not record it, but there are 2 separate sets of notes from the agents. The FBI 302, the report of the interview, does not match the notes in multiple material ways. In fact, they added things to the 302 that Flynn did not say to create false statements, and they did not put in there things he did say to create false statements. The 302 was kept in an unusual deliberative process within the FBI from January 24th when the interview was conducted until February 15 when McCabe himself approved the final copy of the interview report. And it went through multiple iterations, including the night of February 10th, after they showed some sort of something to Vice President Pence to convince him that Flynn had lied to him, which wasn't true either. He had been honest with the Vice President. And so the FBI created the entire narrative that led to the Flynn prosecution, then with the aid of
And
special
much of this
counsel.
wasn't being revealed to you. You've had to claw to get this information.
Yes.
Like you've gotten information out as handwritten notes from Strzok and the margin and things. And some of that you asked for, but then some, I guess, the Director of National Intelligence, because of requests from people like me and Senator Johnson, we asked for some of this information and they revealed it, but it's turned out to be very much exculpatory sort of information for your client.
Yes, everything that's come out has been totally exculpatory of General Flynn, including the fact that the FBI agents went back from the interview and they did 3 separate briefings at high level, DOJ and FBI, that Flynn was being fully forthcoming with them, was honest, and this includes the agent who interviewed him and had the chance to spend 2 hours
That
with
had not
him.
been given to you?
No,
None of that had been given to
No.
you? And you would think that would be blatantly illegal, even according to the laws we have now on the Brady
Yes.
information. That would be Brady information.
right.
So did they claim that it was classified is why they don't give it to you? Or, well, I guess some of it did get declassified, so they're using an excuse of classification on some of it?
They classified things that showed their own culpability.
Exactly.
Right.
So this is a big complaint about, some people call it just sort of the general overclassification of things in government. But here you have an example of saying, oh, it's secret, but it's secret to try to protect, their side of the
Right.
story.
And we still haven't gotten his interviews with the Defense Intelligence Agency, because one of the things he was very diligent about doing to keep his security clearance, even in the few months he was gone from government, was to fully brief DIA on any of his foreign contacts. So he had met with them before the trip to Russia that everybody wants to make a big deal out of, because Putin wound up sitting at his table for 10 minutes, literally, and people got that one photo where Flynn's going like this, and Putin's sitting over there, and they want to make it sound like he had some huge Russia contact there when he didn't even know Flynn was going to be at the table. But DIA had prepared him for that trip, and he reported back to DIA all of the information from it. In fact, he did a lot of work for DIA, and that included his Turkey contacts that people want to make something out of too. DIA knew all of it, and we still haven't gotten the reports that DIA did that show that.
One of the other criticisms, people say, well, gosh, General Flynn was head of the Department of the Defense Intelligence Agency. Sure, he knew they were listening to his phone call when he talked to Kisler.
He did, and he told McCabe and the FBI agents, I know you've got transcripts of it, look at the transcripts.
Yeah, and this gets back to this sort of another sort of criticism of the way this all originated, and the question is how does the Constitution apply to listening to people's phone calls? You can listen to people's phone call by getting a warrant, and under the Constitution it would be a probable cause. Well, a probable cause is either something's getting ready to happen or has happened, a crime. But with FISA or with national security letters or things that apply to foreigners, we lower the standard. And I'm not completely against that. I mean, listening to other ambassadors, spying on foreigners, listening to people overseas. The Constitution doesn't really apply to everybody around the world, it applies to us. The problem is that many Americans talk to foreigners. I talk to ambassadors, General Flynn's probably talked to hundreds of different people around the world as part of his job.
Yeah, he's making 30 phone calls to foreigners every day.
Yeah, so then the question is though, when does an American, and we use the same standard, should General Flynn have the Constitution protect him on what they can listen to, or should he be subject to a lower standard? So with FISA, the standard I believe is relevant to an investigation, which is sort of like no standard as far as I'm concerned. It's like anybody that's investigated, anything would be relevant, so it's really almost no standard, but it's definitely not the constitutional standard. And so what is your opinion on that, on what we should do with Americans being caught up in sort of listening? We listen to so much, but what about an American? What should the protections be for the American?
I think it should be absolutely probable cause. And there's nothing in the FISA applications for Carter Page that constitutes probable cause. I mean, I used to help DEA agents and FBI agents write search warrants all the time when I was a prosecutor and taught at the DEA clandestine lab school on how to write search warrants and things. I read the Page search warrant in the Steele dossier. It's smoke tied with baling wire. There wasn't a single allegation of personal knowledge of any wrongdoing in those documents, not one. You couldn't get a search warrant for the known crack house down the street with allegations like that.
And wiretaps, when you get them, can still be done in secret. You go to a judge in secret, but still the standard's probable cause. And then later, if that person's brought forward, their attorney can then contest, well, the judge didn't use the right standard, or there really wasn't probable cause. But with like a FISA warrant or with a national security letter, the target's never even told sometimes.
Right.
They never know what's been listened to. And then it also leads to whether the phone calls are legal or constitutional, the listening to the American aspect, but then the idea of they're supposed to mask these people. So, General Flynn would be masked, so you're not supposed to know it's him, which I think is kind of hard also because he probably introduces himself at the beginning
Right.
of the phone call, but he's masked supposedly. But then I thought this was explosive news in the last couple months when Director of National Intelligence Rick Grinnell released or declassified how many people and who they were had basically specifically gone in, unmasked that person so they could know about that person. And who were some of these people, and what do you think the motive was?
I have no idea what the motive was, other than they were pulling out all the stops to try to frame him with something.
Right. But some of these people were like the vice president was listening to this. What national security reason was the vice president?
People in the Treasury Department.
Yeah, but 39 different people unmasked General Flynn to listen to it. And this is something that I care deeply about because I'm afraid that the same way Sidney's been concerned about prosecution having too much, I'm always worried about government having too much power in general, but every aspect of it, not just prosecution, but also our intelligence agencies. So our intelligence agencies do good things, we have to have intelligence. But at the same time, we need to be careful about how Americans get caught up in it. Because the thing is that, for example, politicians talk to foreigners, so do journalists. And the First Amendment's a pretty important thing in our country too. So if you have journalists, even journalists you don't like, but they're talking to people in the Middle East who are their sources, it'd be easy to listen to the person in the Middle East because there's almost no standard of listening to them. But really, should you be allowed to listen to an American journalist's phone call? I think absolutely not. There used to be some rules about how they were supposed to actually discontinue listening at some point. Are you aware of that?
It's called minimization procedures that are supposed to be followed.
But not just minimizing the name. I had heard at one time, if they know it's an American, they're supposed to quit listening completely.
Right, like they're supposed to quit listening if they realize you're talking to your lawyer, even if they have a Title III wiretap.
And you think that's a problem too?
Yes.
So I think we do need to be very careful, and I appreciate what you've been doing, not only just for General Flynn. I've never met him, I don't know him personally, but I think it's important for the implications for our country, really, that the way I look at it is if they can do this to a guy who's been in the military for 37 years, a prominent person who's been part of intelligence, if they can do it to him, can you imagine what they do to a Carter Page or to just somebody who lives in your town?
Or somebody who has 1 or 2 strikes against them. If they're picked up for anything, somebody that doesn't have the social standing, the community connections, the faith base, the family, the financial resources, the social resources, I mean, they're just absolutely screwed. I mean, look at Alice Marie Johnson. Thank God the president pardoned her. I mean, Trump did the world and her a great service when he pardoned her. She was in prison for far too long for making a few phone calls that turned out to be drug related. And I think she got like a 25-year sentence. Her children had to grow up without her and everything. She's a lovely person. She's written a book. In fact, I saw a banner for it at the airport. I don't remember the name of it right now, but if you ever get a chance to just listen to her story on YouTube or anything, please do.
So we're getting probably to the close of this. We're going to do a few questions and then think about maybe after we do a few questions, telling us a few things about what you would like to, just suggestions on what we could do legislatively to fix some of these problems, some protections for the innocent and protections to make sure prosecutors aren't trying to win at all costs, but are trying to actually find justice. But before that, why don't we see if we have any questions? If you do have a question, raise your hand, but also pull your mask down so we can see your mouth and understand what you're saying. And stand up and tell us your name and where you're from.
Let's go. Yeah, go ahead. Looking at me? Yes. Okay. Something that I found most interesting. Oh, my name's Elias. I'm from
You broke the first rule before you even
that's
started.
right. My name's Elias. I'm working in Senator Lee's office. I'm from Utah.
Great.
So something I found quite interesting about the Michael Flynn case in general is it seems that even after the prosecution or the State Department moved to drop the case, the judge overseeing the case, for whatever reason, didn't accept that, or what exactly is happening there? Because I heard that he's also appointed like an amicus curiae to continue to investigate it even after the the Justice Department has stopped the case. So like, what authority do judges have to do that?
None. That's what we're litigating right now. In fact, it's never been done before, to my knowledge. A lot of firsts in this case. A lot of FBI conduct that I hope has never been done before, and then Department of Justice Special Counsel conduct that I unfortunately know has been done before. And then now Judge Sullivan refusing to grant the government's motion to dismiss. He appointed his own friend as an amicus curiae of the friend of the court, Mr. Gleason, who had written an op-ed for either the Washington Post or the New York Times, just absolutely excoriating the president and Bill Barr for having moved to dismiss the Flynn case, never mind the raft of documents they gave us very late, only this year, showing all the more reasons he should never have been prosecuted and how the FBI made it all up. Sullivan hasn't looked at that or addressed that at all. And the greatest irony is that Judge Sullivan called him for 6 years the judicial hero of license to lie, because he is the judge I brag on for at least 2 full chapters there for holding the government responsible for producing Brady material that led to the exoneration of former Alaska Senator Ted Stevens. So for Judge Sullivan not to enforce Brady here has been a huge personal disappointment for me, as well as devastating, I think, to the Brady cause in general, because I always felt like he was one of the best champions of it that we had. And I can't begin to explain why that is. But no, there's a Rule 48A of the Federal Rules of Criminal Procedure that says that the government may move to dismiss with leave of court. The Supreme Court in Rinaldi says that exists to protect the defendant from being harassed by repeated dismissals of the government if they don't dismiss with prejudice. And Judge Sullivan even has a decision he wrote himself, changing a dismissal by the government from just dismissing without prejudice to dismissing with prejudice, so that the defendant could not be re-prosecuted. So he knows that rule very well. I can't explain it. We've also just had an unprecedented first with him, Judge Sullivan, actually moving for rehearing in the Court of Appeals when he's not a litigant. He's supposed to be the neutral umpire that the federal judges are supposed to be, but yet rehearing en banc has just been granted by the DC Circuit. So we argue the case again in front of all 10 judges of the DC Circuit because Judge Sullivan requested rehearing en banc. And the arguments will be broadcast live on Monday at 9:30.
These are arguments that have already happened.
No,
But you're making
the
arguments.
second round.
Okay, second round.
We argued it once, that's on, I think it's on my website, as well as the court's website, but we're arguing it again for all 10 judges on this Monday.
Hi, thank you. I'm Noah from Pennsylvania. My question is that we the people really don't have the power to fire these career prosecutors or career public servants through election. So when we see them behaving badly, what are some ways we can hold them accountable?
It's extremely difficult to do. That's one of the areas we need Congress to work on. I know Senator Murkowski has thought about and introduced previously reform legislation to put more pressure on prosecutors to produce Brady material and to put in sanctions if they didn't. And I think we need to eliminate the absolute immunity that prosecutors currently enjoy, at least change it to qualified immunity, particularly for intentional misconduct, which is what General Flynn experienced and what Ted Stevens experienced too.
I'm a big supporter of their reforms. I'm a co-sponsor of Senator Murkowski's bill and also of Senator Sullivan, who has a similar bill. But what I would also say is that the only reason there is any justice in this is because our legal system has an adversarial approach. Sidney Powell is representing General Flynn. If he didn't have representation, there would be no adversarial process and there's no way you get to justice. The reason I mention that is that if you get into the FISA world and you get into the national security world, there's a world where you don't get a lawyer. So they've actually talked about in FISA trying to reform it by saying, oh, we'll appoint a friend of the court to be your friend or your kind of your lawyer. Well, that's not quite the same thing. You really want somebody who is your lawyer. And so it sounds like it's something very simple, but it's incredibly important that we have an adversarial process. They vie, each one of them, and facts are confusing. Think of that Enron case with all the business rules and laws. I couldn't even describe the case accurately because it's complicated. But you need to have people on both sides of it, and that's why we should almost never, and I think never, have an American caught up in a secret court where they don't get a lawyer. That should be so basic that you get your lawyer, you get your day in court, and it has to be public. And in addition to that, we still have to keep modulating because the government always has more power, more information and more power. So the Brady information, trying to make sure that that's put forward is better. Why don't we do one more? We have one more here? Yes.
Hi, thank you for coming to speak with us today. My name is Rachel. I'm from DC. Given your experience exposing Fourth Amendment abuses within federal law enforcement, I was wondering about your take on a specific Department of Homeland Security policy. Currently, almost 2/3 of Americans live within this 100-mile border zone where Customs and Border Patrol can legally search and detain anybody without a warrant or without probable cause. And I think a lot of people are perhaps not aware of that. So with Fourth Amendment abuses like that, what do you think it would take to make more people aware of that and to potentially open the doors for policy changes in the future?
Well, actually, I wasn't even aware of that. I know that there's some places that are qualified as checkpoints equivalent to the border where they can stop and search without articulable suspicion or probable cause. But I didn't know that there was a 100-mile long.
We're looking at this, and this is our understanding of it, is that we've given too much power to DHS. It's one thing to say somebody's crawling over a fence, can you detain them and, not have, well, you might have probable cause if you see them crawling over a fence.
Yeah.
But 100 miles from the border is a long way from the border. And so you can see how, particularly if you're Hispanic and you live within 100 miles of the border, you shouldn't have to give up your rights, because you live 100 miles from the border, you happen to be Hispanic and we have an illegal immigration problem, you shouldn't just be snatched up without any kind of probable cause. So we're worried about it, we're looking at that and seeing if there's some kind of reform, and we're in the middle of still looking at that to see if there can be a reform. But thanks everybody for coming. Thank you, Sidney, for doing this again this year. I'm sorry we couldn't do as big a crowd in person. Well, if you wouldn't mind just finishing up, tell us maybe one or two things from the legislative point of view that you think we could do would be the most important things to make sure. See, it's one thing to exonerate General Flynn, it's another to say this shouldn't happen to someone, particularly someone who can't get a famous lawyer to defend them and may not be as lucky. And actually, I wouldn't call him lucky. I mean, I would say he's still been through hell.
Yeah, I mean, we're not through yet.
Yeah.
He can't live his life yet. It's absolutely unbelievable. Said Judge Sullivan hijacked the case on May 7th. Every single case in the country that the government has moved to dismissal has been granted. Because if the government isn't going to prosecute it, nobody else can. It's part of the Article 2 core powers of the Department of Justice and the executive to decide when, where, and how to prosecute someone. So there's never been the denial of a motion to dismiss that has survived appeal. And this motion was particularly substantive. It was 20 pages of briefing and 80 pages of new material that had been suppressed for 3 years. So it's especially egregious. One of the things that I think needs to happen is codification, essentially, of the Brady Rule with sanctions, including disbarment. And the bars need to do a whole lot more to monitor this behavior. They do nothing, absolutely nothing, to rein in abusive prosecutors, no matter how much the evidence is against them. Essentially, if the court doesn't find it was material to the case, and the courts don't want to do that because that means reversing a criminal conviction, then nobody does anything about it. That happened in the Ted Stevens case too, despite a 500-page report by an independent prosecutor, essentially, that Judge Sullivan had assigned to look at it, who found intentional, pervasive, and systematic misconduct within the Department of Justice. Nothing happened. So Congress is going to have to do something there, and I think abolishing absolute immunity for prosecutors, especially for intentional misconduct, is definitely going to have to be done. I also think the FBI should be required to record all their interviews with people, and that no interview can be used to prosecute someone for a false statement unless they were warned that any false statement they made could be prosecuted.
I think that last one's a good one, and we'll look at that in our office and see if anybody's talked about doing that. That seems like a simple reform, but would go a long way.
It would help a lot. And the other thing is to add a sentence to Section 1001 that says no false statement case can be prosecuted on the basis of simply the word of FBI agents. There's got to be a recorded interview.
Well, thank you very much for all you're doing. We wish you luck with the General Flynn case. If anybody wants to read more, The License to Lie is a great book, and I highly recommend it. And you have another book too. Tell me
The second book is called Conviction Machine. I co-authored that with Harvey Silverglade, who wrote 3 Felonies a Day, that I would also commend to your reading, about how over-criminalized we are in general. And now add the mass penalties to that, and it's gone insane. And all the monitoring that's going on with that. I mean, we're losing civil liberties by the day. We've got to get back to a free society that doesn't dehumanize you with your masks and our masks and all of this. It's just really
That's
disturbing.
another huge problem, is just the overzealous criminalization of everything at the federal level. It used to be there were very few crimes, treason and hijacking a ship at sea. There were a few crimes, but there weren't many. But now we've federalized so many things that you can actually go to jail for not putting the right calorie count on your menu in your display for your restaurant.
Right,
The criminal
or throwing your
penalties
fish
for almost
overboard.
everything. Yeah,
Yeah.
it's kind of ridiculous. But thank you for what you're doing, and thank you for volunteering. We don't pay anything to have Sidney Powell come here, but thank you for volunteering and doing this so we can get some knowledge out to our young interns.
Thank you for having me, and thank you all for caring. You're the ones that have to fix the mess.